to oppose this bill, as we have throughout this process. I want to put on the record of the House that the Labor Party is deeply concerned about increasing crime rates. We're especially concerned about reoffending rates, and we care deeply for victims of crime, no matter where that crime takes place in New Zealand. And for those are some of the reasons why we oppose this bill, because quite simply this bill does not address the causes of those crimes, it does not seek properly to address the reoffending, and it certainly does not reach out to victims. In fact, it could be argued that in many ways it will put victims under more stress, and I'll return to that shortly. Mr. Speaker, we oppose this bill because it gives false hope to victims and their families. It's unworkable, unjust and inequitable. And if we continue to park ambulances at the bottom of the cliff of crime, we will not address the causes of crime and we will not reduce crime and its impact on society. I'm going to return to these specific matters shortly, but I do want to raise now several process concerns that the Labor Party has about this bill. The major one of those is the role of the Ministry of Justice, or the lack of the role of the Ministry of Justice throughout the process of this bill. It's important to know that the Ministry of Justice were prevented, Mr. Speaker, from having a role as advisers to the Select Committee by National Party members of that Select Committee. I think this raises an extremely serious issue for Parliament around where Parliament gets its advice from. Not where the executive gets its advice from, but where Parliament gets its advice from. In our system, there are very important distinctions made between the operational arms, such as the police, and the Ministry of Justice, who are the policy arms. That has been blurred by this government, and it has prevented parliamentarians from being able to seek the advice that they need to make decisions in this House. And I believe, Mr. Speaker, that represents a significant and a serious letdown by this government. But perhaps, Mr. Speaker, we can see why the government didn't want this Parliament to have the Ministry of Justice advising the Select Committee. I'll quote from a Ministry of Justice paper that went through to the Minister of Justice on this bill. Quote, "The proposals will add substantial direct costs to the justice system without creating any significantly improved outcomes in terms of reducing the drivers of crimes, improving social outcomes or reducing reoffending and victimisation." Mr. Speaker, those are the words of the Ministry of Justice. Those are the words of the government's chief advisers on justice issues. And this government has chosen to ignore that advice and, what is more, chose to prevent a parliamentary select committee from having those people as the advisers on this issue. That is a disgrace. It is a mark against the chair of that Law and Order Committee, and it is a mark against the whole government for preventing those parliamentarians from getting that advice. I also want to note, Mr. Speaker, that the Select Committee didn't hold oral submissions on the bill after, as the Minister herself just acknowledged to us, it was substantially amended. No oral submissions were held on that. Written submissions were required with 2 weeks' notice to submitters. That is unacceptable for what we all recognise is an extremely serious change in our system. This whole process has been rushed through by this government for political imperatives rather than trying to find the best possible law that can help protect New Zealanders and keep our communities safe. And I think, Mr. Speaker, before I leave the whole question of process, the fact that the responsibility for this bill transferred from Simon Power as Justice Minister to Judith Collins as the Police and Corrections Minister speaks volumes for this bill. I think we know, and some light was made of this in the committee stages, Mr. Speaker, about Mr. Power being rolled by Mrs. Collins and having this bill that he loved taken off him. Well, I want to get serious in this third reading of this matter. I suspect Simon Power is somebody who understands that this bill is unjust, unworkable, and simply should not be going through our Parliament today. And it has gone to Mrs. Collins to put it through in leading the charge on behalf of the ACT Party. And I think as the Minister of Justice and the Ministry of Justice don't seem to want to be part of this bill, surely that must raise questions for this government and for the country as to whether this bill should be passed. Mr. Speaker, I want to move on to some of the substance of the bill now. And I think the issues that were raised in the committee stages in particular were about whether this bill can actually achieve the things that we want it to achieve. And one of those things is about deterrence. And we all agree that we want people to be deterred from committing crimes. But no evidence was presented to us that this bill will actually do that. In fact, quite the contrary. Internationally, the evidence was presented that deterrence will not be improved by this bill. Greg Newbold, other experts said this is simply not an effective way to improve deterrence of crime. So we were offered no proof in that regard. We also managed to come across, and the Speaker talked, the Minister has already talked about the question of the definition of manifestly unjust. There was an opportunity in the committee stages for the Minister to take up the point that the regulatory impact statement says, where they say that this creates a disproportionate system. The Attorney-General, in his Bill of Rights Act submission, said it was disproportionate and severe, but no attempt was made to do that, because it's easier for the proponents of this bill to obfuscate and say that the manifestly unjust provision is in there. The bar of that is set so high, Mr Speaker, that there is no doubt that there will be disproportionate outcomes coming out of this bill. Mr Speaker, another area is the whole question of judicial discretion. And I think it's very important to note that even the Police Association came out against that aspect of this bill. Even the Police Association felt that this would shift away from judges having discretion and into the hands of the police. And we know that that's the case. The only point in this process is at so-called strike one, where the judicial system will continue to have discretion. After that, it shifts to the police. Well, let's hear what the Police Association say. Judicial discretion provides a safety valve for the myriad of possible circumstances surrounding any given case and is preferable to mandatory sentencing. So that's the police. That's actually the police themselves, the officers themselves, saying they would like to see judicial discretion retained in here, but no, the government didn't want to listen to that. There will be less transparency in the system, Mr Speaker, as a result of moving away from judicial discretion to one where the police are playing a much greater role. Now, our police are a great force, and I don't like the idea that they can be accused of corruption, but this puts them into that frame unwillingly, because the Police Association themselves have said that they didn't want that. The other thing that a number of experts have raised is the fact that there will be fewer guilty pleas as a result of this legislation. Fewer guilty pleas means greater costs on the system and more stress for victims. It will put victims in court when they need not be there, because there's no doubt that somebody facing the consequences of the scheme will think twice about whether they want to plead guilty. And as a result, greater costs, more stress for victims. One of the things that's been raised time and time again in this debate is the importance of community safety. And this is where we did attempt in the committee stages to be able to get some measure of agreement that we all want our communities to be safer. But the problem with this bill is that it will not necessarily do that. The New Zealand Prisoners Aid and Rehabilitation Society said in their submission they do not support this bill because it will not achieve a safer New Zealand. John Pratt, a criminologist from Victoria University, said the realities of the three strikes bill is it's more likely to endanger community safety than a preventative detention sentence. So on substance, Mr Speaker, this bill fails. But where it really fails, New Zealand, is in principle, because we all want there to be less crime. But to get less crime, we need some real leadership from this government. This is actually the easy bit. This is the easy bit, Mr Speaker, because this is a populist bill. The hard work is about making sure that people do not end up in prison in the first place, that we actually address the causes of crime, that we intervene early, we help with parenting, we reduce poverty, and then when and if people do commit crimes, we support reintegration and we support rehabilitation. That actually requires leadership, Mr Speaker, and this bill does not deliver leadership. We need to solve the problems of crime at the beginning, not at the end. We shouldn't be parking the ambulance at the bottom of the cliff. We should be trying to endeavour to build the fences and create the environment at the top of the cliff that will prevent crime. This bill gives false hope, Mr Speaker, and it should not be passing through this House today.
Hear, hear. I call Sandra Garvey.